So this is the third part of general exceptions. So today we will study right of private defense. So section 96 to 106 talks about right of private defense in IPC, whereas in Bharatiya न्याय Sanhita, section 34 to 44 talks about right of private defense. So section 96 says that things done in private defense. So nothing is an offense which is done in the exercise of right of private defense. So section 96 gives a right to every person to defend his body or property and also the body and property of other person against unlawful aggressions. So it is the right of every person to protect himself and his property. So it says that nothing is an offense which is done in the exercise of right of private defense. Section 97 talks about right of private defense of body and property. So every person has a right of private defense both against body and property, subject to the restrictions contained in section 99. And you can see the section of Bharatiya न्याय Sanhita of right to private defense. I've written all the section of IPC and Bharatiya न्याय Sanhita, so you can compare it. So section 98 talks about right of private defense against the act of a person of unsound mind. So the right of private defense of body or property is exercisable even if the person against whom such defense is invoked is a minor or unsound mind or a person who is heavily intoxicated. So this means that the capacity or incapacity of the attacker does not diminish the defendant's right. So even if the attacker cannot be held legally responsible due to their conditions such as heavy intoxications, unsound mind, insanity, the defender is justified in protecting themselves against harm. Important point in this section would be you cannot use excessive force against a minor or intoxicated person who poses a lesser threat. So the exercise of right must be proportionate to the harmed threatened, and the right of private defense is valid only when the act of a defense is necessary and there are no reasonable alternatives available to avoid the harm. So suppose G under the influence of madness attempts to kill A. A is guilty of no offense, but A has the same right of private defense when he would have if G were sane. So G attempts to kill A. So here A has a right of private defense even against a person who is insane. So the next section is section 99, which talks about acts done in the right of private defense. So this section defines the limitation and restrictions on the right of private defense, while section 96 to 98 establish and expands the right. Section 99 clarifies that the right is not absolute and cannot be exercised under certain conditions. So let's see all the conditions one by one where the right of private defense does not extend. So the first is by a public servant. So the right cannot be used against public servant acting in good faith even if their act is technically unlawful. So the act done by a public servant who is doing the act in good faith under the color of office, and even if their act is not justified by law, the right cannot be used against him. So suppose if a police officer confiscates a property in good faith, then the defendant cannot physically resist him in the name of private defense. So the next is in obedience to law. So if a person is acting under the direction of public servant in good faith, the right of private defense cannot be exercised against them. So the third is no apprehension of harm. So the harm caused in private defense should not exceed what is necessary to prevent the harm. Suppose killing an unarmed attacker for a minor threat is not justified under this section. But there is a condition that unless there is no reasonable apprehension of death or grievous hurt, the person cannot seek private defense against public servant under the direction of public servant and if there is sufficient time. So there should not be the apprehension of death or grievous hurt. If there is an apprehension of death or grievous hurt, then that will be the different condition you will see in section 100. This is all about section 99. Let's see section 100. So let's see section 100, which talks about right of private defense of the body, which extends to causing death. So it says that right of private defense of the body extend under the restrictions mentioned in the last preceding sections. So the restrictions that was mentioned in the last preceding sections, that was the right of private defense cannot be exercised against a public servant in the order or obedience of the public servant, or when there is no apprehension of harm. So except these three conditions, a person can exercise the right of private defense to the extent of causing death. So what are the conditions? There are 5 conditions given. So first is there should be a reasonable apprehension of death. Second is there should be a reasonable apprehension of grievous hurt, or there should be an intention of committing rape or gratifying unnatural lust or kidnapping or abductions. So the condition mentioned here should be grave and imminent. So if you compare section 100 and 103, both are similar, but section 100 talks about the offense against body, whereas section 103 talks about the offense against property. So this section says that when the right of private defense of property extends to causing death. So it specifies the circumstances in which the right of private defense of property permits a person to cause the death of that offender. It established that in situation of grave danger to property, the defendant may take extreme measures to protect it. So let's see what are the acts that fall within this section. So the conditions under which a person can have a right of causing death to protect his property is, first is if there is an apprehension of robbery or house breaking by night or mischief by fire or theft, mischiefs or house trespass under such circumstances as may reasonably cause apprehension that death or grievous hurt will be the consequences. So if we compare section 103 and 100, here the right extends to causing death to protect property. Here the right extends to cause death to protect body. So the nature of offense in section 103 is robbery, house breaking by night, mischiefs by fire, theft with danger to life. Here it's murder, rape, grievous hurt, kidnapping, abductions, unnatural lust. The applicability of threat here is to property, and here it is threat to life or limbs. If you see the other sections, section 101 talks about when such right extends to causing any harm other than death. So this section deals with situations where the right of private defense of the body does not extend to causing death, but permits causing harm such as grievous hurt or simple injury to protect oneself or other person. Section 102 talks about commencement and continuance of right of private defense of the body. So it specifies when the right of private defense of the body begins and ends. Here it defines the temporal scope of this right, where it emphasizes that it exists only as long as the danger is imminent and continues until the threat subsides. So the right begins when there is a reasonable apprehension of danger of body. O says that when such right extends to causing any harm other than death. So here this right deals with situations where the right of private defense of property does not extend to causing death, but allows causing other type of harm such as grievous hurt or simple injury. So here if you compare section 103 and 104, both are against property, where in section 3 it extends to causing death, whereas in section 104 it extends to causing only harm. So the harm permitted extends to causing death only. Here it is limited to causing harm other than death. So the nature of offenses here are robbery, house breaking by night, mischief by fire, theft, mischiefs or house trespass where there is reasonable apprehension of death or grievous hurt. And here there is simple theft, mischiefs or criminal trespass. So the severity of threat here is grave and imminent danger. Here the severity of threat is less severe offense. So if you see section 105, it talks about commencement and continuance of right of private defense of property. So this section is similar to section 102. So here it talks about the time frame within which the right of private defense of property can be exercised. So it signifies when the right begins and ends depending on the nature of the offense. If you compare these two sections, section 102 talks about body, whereas section 105 talks about property. So here the reasonable apprehension of danger to the body is there. So here the reasonable apprehension of danger to property is there. So the duration is until the threat to the body subsides, where it varies based on the offenses. The type of defense here is protection of life or limb. Here it is protection of property. Let's see section 106. It talks about right of private defense against deadly assault when there is a risk of harm to innocent person. So this section provides legal protections to a person exercising the right of private defense when their action unintentionally harm or risk harm to an innocent person. And it recognizes that in life-threatening situations, self-defense may involve collateral damage and the defender cannot be penalized for such unintended consequences. You see the illustration, it says that A is attacked by a mob who attempts to murder him. He cannot effectually exercise his right of private defense without firing on the mob, and he cannot fire without risk of harming a young innocent child who are mingled with the mob. So A commits no offense if by so firing he harms any of the child. So here it gives right of private defense to the actions that is unintentionally harm or the risk of harm to an innocent person is there. So let's do a one thorough recap. Here the right of private defense is defined in section 96. Right of private defense against body and property is defined in section 97. Section 98 talks about right of private defense against unsound mind, insanity or heavily intoxicated person. Section 99 talks about the limitation of right of private defense where there is no right of private defense against a public servant, a person who is obeying the order of public servant, or where there is no reasonable apprehension of harm. And section 100 talks about right of private defense extending to causing death of a person where there is a reasonable apprehension of death, grievous hurt or rape, unnatural lust or abduction or kidnapping. And section 102 talks about extension and continuance of this right. And in property, similar to section 100, here section 103 gives the right of private defense of causing death where there is a reasonable apprehension of causing robbery, housebreaking by night, theft, where grievous hurt or death be the consequences. So this is the thing. And section 105 gives the continuance and right of private defense against property, similar to section 102. Important section of this part is section 106, which talks about the legal protections to a person exercising the right of private defense when the action is unintentionally harm or the risk of harm is to the innocent person. So this is all about right to private defense. So if you like this video, please do like and subscribe my channel for more upcoming videos. So thank you.